Welcome friends. So, now we are moving to applications of this portfolio management. When you have a large number of assets in your portfolio, it is also very important to keep security of those assets. Now, you will argue that because we have already protected our technologies, all these technologies are protected technologies. We have received the grant of patents, we have received the grant of registration for the designs, we have received the grant of trademark. So, this is already a protection, this is already a security. What next security you are talking about? The grant is one part. It is like your land, your property is registered in your name, but it is always possible that there may be some unauthorized person who may try to use your property without your consent, and that is where the next level of discussion comes into the picture, that if there is someone who is trying to use your IP without your permissions, we have to go to the court, and this is known as IP infringement. So, in this particular session, we are going to focus on this IP infringement. In fact, let me also tell you that there are organizations which are running their business models around this IP infringement. They will try to sue you that you have used their IP without their consent, so you have to pay this much amount as compensation to them, and so that is not a very fair use of IP. But if I talk of in all fairness, if I have something with me, I am the owner of a particular property, I will not like my property to be used without my permission. Whether I want money or I do not want money, that is a second matter, but my permission, whether I have authorized that user for using my property or not, that is a very important thing. So, in this particular session, we are going to discuss this issue of patent infringement, IP infringement, and this is going to ensure the success of my portfolios. So, in this particular session, we are going to talk about what are the different types of IP infringements, basic features of patent infringement, then who can enforce rights against any infringer, how patent infringements can be prevented. It is very important. It is both policy level versus managerial issue, that how you can reduce, prevent your patent infringements. Then defenses to patent infringement, that how you can defend your patent infringement. Particularly, we are going to speak about the Indian Patent Act, which is helping you whenever there is a case of infringement, when you are going to court about your particular issue of IP infringement, you have to take the help of this Indian Patent Act. And then what are the remedies etc. are available for a patentee in case of patent infringement, and all these things we are going to discuss with the help of some very popular infringement cases and the verdicts given by the courts in respect of those popular cases, so that we can understand that whenever there is a case of IP infringement, both the parties, there are very serious consequences of the IP infringement, and millions of dollars of compensations are paid if the case is proven. So, as we already know right from the beginning of this particular course, that a patent owner has the right to exclude all others from using the patented invention. Here I am writing it in a slightly different way. Generally, we say that a patent owner, IP owner has the exclusive right to use it. Generally, we say that if I am owning a particular IP, I have the exclusive right of using this particular product. But here I am saying that I have the exclusive right to exclude all others from using my invention, that you will not use, you will not be able to use, you will not be permitted. So, I am excluding all of you from using my patented invention. Only I will decide who will use, who will not use. So, I am able to, that is the right of excluding. It is not a public property, it is a private property. So, I ensure that who can use, who should not be used, and right related to anyone who practices the invention without the owner's consent infringes his rights. So, therefore, whoever is going to use my IP without my consent, is amounted to infringement of IP. If you start using my invention without my knowledge, without my permission, it is considered to be infringement of my IP rights. So, patent protection, we all know since beginning of this course, therefore, the issue of foreign filing, therefore, issue of PCT etc. is there, because patent protection is a territorial right. Territorial right means within a particular country you are going to exercise this particular exclusive right, and therefore, it is effective only within the territory of India in our case, or wherever you are. So, within the territory of your country, and we all know that there is no concept of global patent, but there is a concept of foreign filing. So, you can go for foreign filing to take the benefit of this territorial right in different foreign countries. After understanding this basic characteristic of IP with respect to infringement, the three very important types of infringements which you can find in literature, that is direct infringement, indirect infringement and willful infringement. So, let us see what are these different types of infringements. So, direct infringement, which is, as the name indicates, it occurs when a product substantially close to a patented product or invention is marketed, sold or used commercially without the permission from the owner. So, I have this particular pointer, and this particular pointer is from a very popular company Logitech, and another company Globitech. It also makes a similar kind of pointer which uses almost all the technological feature which is available in Logitech. So, that is an example of direct infringement, that is an example of direct infringement, and a very popular very recent case of the direct infringement is Lava versus Ericsson, which came to India's Delhi High Court, and in this case Ericsson's core activities like designing and manufacturing telecom equipments, establishing communication network, then it is leading innovations in the telecommunication, data communication, mobile network. So, we all know about this company Ericsson. In India, we also know about Lava, and Lava is again a mobile manufacturing company. It is making mobiles in India. However, many a times there are some question marks on the Lava's performance etc. Like in this case of direct infringement, it is something related to SEP. SEP, some of you may be aware, is known as standard essential patents. So, whenever you are working in the field of, let us say, mobile communication, you are working in the field of computers etc., there are, or even electrical engineering also, there are certain standard setting organizations which are known as SSO. For example, 5G phones are coming, 6G phones are coming. So, there will be a minimum standard of these 5G phone. If I say that my phone is 5G enabled, so there will be some minimum standard. Because of these minimum standards, you can use SIM card of one company in any mobile phone, or you can use the same mobile phone in India, China, America, Japan, Europe, wherever you want to go, you can use the same mobile phone because of these standards. If standards are not there, we may require a different mobile phone for using Airtel SIM, or we may require a different mobile phone Vodafone and so on. We may require different mobile phones when we travel from one country to another country. So, because of these SSOs, you are having common standards across the globe. So, any 5G phone need to fulfill those minimum standards. You can always have more add-ons on your phone depending upon the target market for which you are going to be there in a particular area, but minimum standards need to be fulfilled. And all those patents which are actually helping organizations to achieve those minimum standards are known as SEP, Standard Essential Patents. So, this term is more popular in the field of mobile communication, in the field of IoT, etc., where you have so much of requirement of standardization. So, Ericsson said that Lava has used their 8 standard essential patents without their consent. So, Ericsson initiated this discussions and discussions with Lava to facilitate the license acquisition. So, they said that you are using our patents without our permission. So, why not you acquire the patents from us? And there is a issue which is known as FRAND, FRAND, which is mentioned as fair, reasonable, non-discriminatory terms, because these SEPs are essential for making a particular device. So, there is always a issue that if SEPs are given on a very high commercial rates, the price of that particular product will also increase because of high royalty payments. So, governments are trying to do a system which is known as FRAND, that all SEPs are given to users whenever there is a technology transfer on this FRAND terms, FRAND terms, so that the cost can be kept within some reasonable limits. Otherwise, it is very difficult for users to purchase those products because of the IP royalty issues. So, Ericsson said to Lava that okay, we are ready to give you this these particularly 8 SEPs on the FRAND term, you please sign the agreement. But Lava did not agreed with Ericsson's offer, and they, without taking any kind of licensed agreement with Ericsson, they continued using these products. Then Ericsson had to go to the court. Ericsson sued Lava that they are using their products, their technologies, IPs, and it became a case of direct infringement. And then the Delhi High Court gave its ruling in favor of Ericsson, and around rupees 244 crores, rupees 244 CR was given from the, as per the order, from the Lava to Ericsson for the royalty or damages which Lava made to Ericsson. And in this discussions also, when Ericsson was saying that 8 SEPs were used by Lava, Delhi High Court agreed that 7 SEPs were actually used by Lava, but one was not amounting to SEP. So, court actually decided that which are the SEPs and which is not the SEP. But the point which we are discussing, that is about the direct infringement. So, this proved the direct infringement technology is as it is used by Lava. Then comes the second type of infringement, that is indirect infringement. Now, indirect infringement is not done directly by the person who is using it, but there is a third party support. This is owner. Now, owner to a third party, and this third party is giving to a person who is infringed. He is the infringer. So, in this way, this is not a direct infringement, but through this third party involvement, it is the indirect infringement. This third party is actually promoting the direct infringement. Third party is supporting or providing the technologies from this owner. So, there are intentional, accidental, both these things Generally, it appears to me that it is more intentional than the accidental, because of the commissions or some other kind of favors which this third party gets. So, they are trying to sell the technologies, provide the technologies which otherwise may not be copied. Then the third type of infringement is willful infringement. Now, this willful infringement involves intentional disregard for another's patent rights and encompasses both direct and intentional copying and continued infringement after notice also. So, you can say that out of three, direct, indirect and willful, the willful is the worst kind of you can say infringement, because you are aware, you are doing intentionally this kind of infringement, and you are continuing even after the notices. So, somebody has noticed that you are infringing their IP and they are sending you some kind of legal notice, but still you are continuing with your practice of copying or infringing that particular IP. So, this is a case of Glenmark, which is a very popular name, and Simon Labs of 2015. Now, in this case, Simon Lab had used Glenmark's before the Delhi High Court for allegedly infringing two of its patent. Both of them are Indian patents. So, Simon Lab asked Delhi High Court that Glenmark is actually infringing. Glenmark is a big name. So, first patent was granted for this particular invention, while the second patent was granted for novel process for the preparation of linezolid and related compounds. So, both are in the pharmaceutical fields. Now, in this case, the judgment which was declared on January 2015, you all can also refer this judgment, which is available online also. The judge was convinced that the plaintiff had good prima facie case in favor of Simon. He further decided that protection to the patent processes ought to be granted to the plaintiff, as damages will not be an efficacious remedy. There was an irreparable loss and injury because of the long uninterrupted use of patents, and the balance of convenience also lay in favor of the plaintiff. Thus, the judge granted an interim injunction restraining Glenmark from manufacturing, selling, offering for sale, advertising or directly or indirectly dealing in the production of linezolid manufactured in a manner that results in infringement of the plaintiff's registered patents. So, here just said that whatever loss has happened to Simon because of the continued uses of this particular product linezolid, Glenmark. So, it is impossible to actually recover that losses, and immediately stopped the manufacturing, selling and offering of sale, advertisement etc. of this product by the Glenmark. So, this is a willful infringement where Glenmark knowingly, intentionally they were copying or they were infringing this particular IP of Simon Labs. Now, you may also understand or you may also argue, then what is the difference between direct infringement and willful infringement? So, direct infringement and willful infringement, it appears to be similar, that in both the cases there is quite a bit of similarity, but in direct infringement, once it is noticed, you stop your activities, while in case of willful infringement, even after notices you are continuing, you are still going into the path of that infringement. So, that is therefore, I say that willful infringement is even more you can say of the lower quality of infringement. So, whenever you are going to have a patent infringement case, the patent must be a valid one. If it is a dead patent, it will not be amounting to the infringement. Then infringer must infringe with the purpose of operation or production. That means, there should be some kind of commercial gains from this infringement. If there is no commercial gain, For example, it is used for some kind of a developmental activity, it will not be amounting to the infringement that way. And when you are using those patents or IP without the permission of patentees, that is the violation of the legal rules. So, there are three important features of patent infringement. Now, who can actually enforce rights against the infringers? Because there may be lot of people who are involved in holding the rights also. So, patentees themselves, assignee of the patent. So, you can say kind of a representative of patentee, agent. There are some IP agents, they can also enforce rights against the infringers. The licensee of the patentee, you have done the some kind of license agreement for this particular IP with somebody, and because that person is holding the license for some kind of commercial interest. But now, if somebody has infringed, the benefits of this licensee will also be reduced. So, therefore, he is also given the permission to sue against the infringers. Now, how patent infringement can be prevented? So, patent infringement can be prevented using multi-prong approach. Now, when I say multi-prong approach, what does it mean? It means that first you need to procure the license from the patent owners. So, that when I am making a product, I need to see that the technologies which I am going to use, whether they are still live protected one or they are not live protected one. If they are live protected one, I have to acquire the necessary license from the owners, assignees of those particular patent. Then production of unique goods. If I am making those goods, those products which are difficult to copy, or even if it is not a good, then if your patent is simply in your almirah, in your website, it is very easy to copy. So, for avoiding, for minimizing the patent infringement, it is important that if you got a patent, because out of three, one very important condition is that you need to have some kind of industrial application of your technology. So, rather keeping your IP idle without any work, you need to make use of your IP immediately, and when you make use of your IP immediately, the chances of infringement gets reduced. Chances of infringements are more when you are not using your IP, and therefore, it remains idle and somebody thinks that it is a very useful technology. So, he starts using it. So, that is the another very important thing, that you need to bring your products to the market, that will help you in minimizing the cases of IP infringement. And then obviously, the third, which I will not recommend generally, but if nothing is working, you need to sue the infringers. So, in India particularly, Patent Acts of 1970, you have given this power to sue if your exclusive rights are violated. Now, when your exclusive rights are violated, you have defenses to patent infringement. Now, the defendant may prove that they are compliant by data that shows they are not infringing, or argue that the asserted patent is invalid if that be a case. Somebody has put me a blame that you are infringing IP of ABC company. So, I have to justify that yes, I am aware of patent of ABC company, but the technology which I am using, how is it different from the claims which are made in that particular IP, and that is my defense, and therefore, we need to go to the court where it will be proved whether what I am claiming or what the IP owner is saying, who is correct. And here comes the role of court also, that court will hear both the parties, and therefore, the capability development of courts are also very important, whether they are able to appreciate the IP related matters or not. Then simple thing is, you may stop selling, marking the infringed products. That is one thing which you should immediately do. If it comes to your notice that you are using any kind of infringed technology, you should stop. You may negotiate licensing fee from the patent owner. It is possible that when it comes to your knowledge, even the patent owner will not like to go to the court immediately. First they will like to have a discussion, okay, no problem, you have infringed my IP, I am justifying that you have actually infringed my IP, but then there can be some kind of commercial negotiation where you will try to, as an infringer you should try to acquire the IP of the owner, so that it becomes more legalized and proper thing, and it should not be amounting to IP infringement that way. And sometime it also happens that I am using a particular technology, you are the owner of that technology, now you are blaming me that I am infringing your IP, but in this case I may also try, it has happened in many cases, I may try that I will say that this IP is itself not correct, this particular technology cannot be given IP, and it is quite possible that court may accept my logic also. So, I will say that defendant may prove that the plaintiff has wrongfully obtained the patent, it is not amounting to patent, maybe because of some prior art issue, maybe because of any XYZ reason, maybe the information was already available in the public domain. So, those things may be possible where defendant may come that your IP is not a valid IP, and therefore, all these strategies the defendant may use for their defense against the patent infringement. Now, there are some cases in which IP infringement is not considered. For example, I am acquiring some product from outside, and that product from outside is already a protected product in our country, but I am not using it for any commercial gain, I am using it for further development. I want to refine it, I want to develop it maybe for the R&D purpose, etc. So, this is not going to amount for infringement. The basic you can say thumb rule can be, if I am making some money from infringing the IP, I am using some IP for my commercial gains without taking your permission, that is the easiest way to understand the IP infringement. If I am using some, I am violating some IP for my these classes, that is if it is these classes are giving me some kind of commercial benefit, yes, I have infringed the IP, but if it is not giving me any commercial benefit, then it will be difficult to get to sue me in the court because of developmental R&D activities which I want to do using this particular IP. So, you can actually use section 107A of the Indian Patent Act, which gives you the permission that you can sue a person. Now, there are different types of situations which are possible with respect to IP infringement. As we already know that IP is a territorial right, you are in India, you are a company A and you have a IP AP. So, anybody who is making similar kind of product using AP is certainly a case of IP infringement. Now, there is another country, China, where AP is not registered. Now, there comes a company B who is making this similar kind of product using AP and distributing in entire China. Though it is a case of IP infringement, but you cannot take any legal action against this company, because IP is a territorial right. So, since you are not registered in China, your IP is not registered in China, you can't do anything. Yes, you can do something if AP is also registered in China. If AP is also registered in China, then you can go there and you can sue this company B in Chinese courts. But you can understand one thing, that doing these things in multiple countries is a expensive phenomena. So, you have to be very careful that there has to be some local partner in China who can take care of all the legal proceedings. Otherwise, it becomes a very difficult case that you have protection in Japan also, you have protection in USA also, you have protection in EU also. Now, everywhere you cannot go. That is, so even though you have IP registered in these countries, but if there is a case of infringement, you are not so comfortable traveling to all the places. That is point number 1. Point number 2, it is also possible that somebody is company C in USA. Now, your IP is not registered in India, and therefore, company in USA, this C company is using your technology in America. But now there comes a importer D in India, who is importing the technology from USA, means the product from this company C. Now, since the product has come to India, now you can sue, because in India you have the exclusive right. So, nobody else can take any commercial benefit of using this particular technology. So, therefore, if the import is happening in India, you can sue them. But if USA is exporting to Japan, to China, to EU, you can't do legally anything in these cases. And probably the role of governments are also very important to set up a good IP infrastructure, good IP ecosystem, so that even these kind of issues can be minimized as much as possible. The only reason is because IP is a territorial right, you can't do anything if it is if your infringement is happening in other country and the business is also happening in other country where you do not have proper protections. So, all these things actually lead us to court. So, whenever there is a IP related infringement related matter, you need to go to the court, and in the court you may have a temporary injunction, which is like a court order, and if this temporary injunction is given, it prevents a party from taking specific action or compels them to do some particular things, like some kind of, let us say, royalty or those kind of payments are given in favor of the plaintiffs. So, it remains very effective until a final verdict is reached. The main purpose of a temporary injunction is to stop someone from the causing serious harm to another party. So, we will discuss that, okay, it will take 2 years, 3 years, but immediately on day 1, if temporary injunction is given, so at least the additional possible damages can be minimized. Then the permanent injunction is also there, it is kind of a final court order. So, that was the intermediate court order, temporary, and this is final court order, and in this case it is also known as perpetual injunction, it is forever. Court issues it after a hearing and upon the merit of the case, and it is sometime involving the patent offices also, so that what are their views, because sometime if you are challenging the validity of a patent, whether patent is actually possible or not. So, those kind of things require the involvement of the patent office also. Damages are also part of the court orders, which are awarded by the court. It can be like a monetary compensation, it will be stopping the production of that particular activity, and generally whatever is the you can say cost of court proceeding, that is also part of your compensation package. So, with this we discuss that IP infringement is a very important area. Only when you are able to properly protect your IP and you can minimize the cases of infringement. Whenever there is a case of infringement, you need to go to the company, see whether there is a possibility of out of court settlement, and if out of court settlement is not possible, you need to actually go to the court, where temporary injunction and then permanent injunction are possible, and many a time this may take very long time also to settle the IP related matters. So, temporary injunction is something which you should immediately request the court, so that you get a temporary relief, so that further damages can be stopped, and it is in fact good in case of infringer also, because then maybe the amount of penalty in the end will increase too much. So, therefore, the immediate one level of you can say relief is provided to the patent owner, and with this way we are able to take more uses from our IP portfolio. With this we come to end of this session. Thank you very much.